Start. Aggrieved by the judgment of trial court, civil appeal number .128 of 2011 was preferred, which was heard and dismissed by the judgment dated 26.11.2012 of Additional District Judge, Mathura, full stop. The lower appellate court had held in this judgment that petitioner-appellant had failed to prove that he had been willing to keep his wife with him or that respondent-wife had declined to accept him as husband, full stop. The lower appellate court had discussed the institution of earlier another suit, which was filed by petitioner in the year 2007 for restitution of conjugal rights but was withdrawn on 24.5.2008, full stop. The lower appellate court had treated this act of petitioner appellant as proof of malafide on his part, full stop. In this judgment, the lower appellate court had also considered the pendency of criminal proceedings initiated by respondent against appellant but had not accepted it as cruelty in spite of the fact that appellant and his parents had been detained in jail in this case, full stop. With these findings, the first appellate court had confirmed the finding of trial court and dismissed the first appeal, full stop. Para. Learned counsel for the petitioner-appellant contended that petitioner and his parents were detained in jail due to criminal case filed against them by respondent-wife, full stop. Apart from it, she has been casting wild allegations against petitioner and his family members, which amounts to cruelty, full stop. He has also contended that the lower court had wrongly shifted burden of proving the fact that respondent was not living with petitioner because negative facts cannot be proved, full stop. He contended that it is the respondent-wife who has been alleging that she had been living with petitioner-appellant from the year 2005 to 2008, full stop. Therefore, the burden of proving these facts were on her, and in absence of any such evidence, the plea of desertion and living separately should have been accepted by the lower courts, full stop. In these circumstances, the judgment of lower courts are erroneous and appeal should be allowed, full stop. Era. The arguments of appellant's side were refuted by learned counsel for the respondent, who contended that there has been a specific finding of fact that no cruelty has been committed by respondent wife against the petitioner or his family members, full stop. He further contended that criminal case was lodged on correct facts, full stop. In criminal proceedings, the charge has been framed and proceedings are going on, therefore, at this stage, it cannot be said that those proceedings were initiated without any basis, full stop. He also contended that respondent-wife is still willing to live with petitioner and it is the petitioner who has deserted her, therefore appeal should be dismissed, full stop. The original petition of divorce was filed on two grounds, full stop. The first was desertion and second was cruelty, full stop. So far as the first point of desertion is concerned, it is admitted fact that petitioner-appellant had filed original suit number 238 of 2007 against his wife respondent under section 9 of the Hindu Marriages Act for restitution of conjugal rights, full stop. during pendency of said proceedings, he withdrew this case and in its place instituted another original suit number 214 of 2008 for divorce under section 13 of the Hindu Marriage Act para. There has been no finding of any of the lower court that during pendency of original suit number 238/2007 for restitution of conjugal rights, the parties were living together, In said suit number 238/2007, it was pleaded that OP, wife, is living separately for more than a year, Thus, the subsequent suit number 214/2008 for divorce was filed after about 1 year of institution of original suit number 238/2007, There has been a specific pleading and evidence adduced by the petitioner husband that his wife respondent lived together only for about 2 weeks till February, 2005, There is no evidence on record that parties had lived together after February, 2005, It was the OP respondent (wife) who had pleaded that she had been living together with her husband from the time of marriage till 2008, but there is no evidence or proof of. In the memorandum of appeal filed before the High Court, in the second appeal also, there was no such plea taken, On perusal of the records, it appears that the deposit was made on 19/12/1978, that was well within 1 month time granted by the trial court by its judgment and decree dated 25/11/1978, Confusion appears to have arisen because notwithstanding the deposit, an application for extension of time was filed, The High Court should have ignored the application and should not have put any emphasis thereon, as verification of the records would have revealed that the payment had been made, Even otherwise, there was no such plea taken by the defendants (respondent herein) about the non-deposit within time granted by the trial court, The High Court should not have acted on an oral submission made by the learned counsel for the defendant, who was the appellant before it, without granting of an opportunity to the present appellants to have their say in the matter, Above being the position, the impugned judgment of the High Court is indefensible, deserves to be set aside, which we direct, over.